Assalamu alaikum and good afternoon, everybody. Thank you for coming and joining us. I must say, before I begin, on a personal note, I've been involved with this project for some time now, and it's truly rewarding to see the depth of academic discourse that we've reached. We started with a very simple presentation just on the concept, on the idea, what we wanted to achieve, and I think we've gotten to a level where we can really tackle the issues and look at a viable project moving forward. What I'm going to tackle mainly in my 30 minutes or so is this idea of governing law. I'm a little bit frightened given the question that Dr. Klutzo has come up with earlier with his governing law clause, including Hanafi law, but hopefully we don't give him the microphone. But I'll do what I can, and hopefully we can trigger some more discussion. I'm obligated, I think, in my contract initially to give you the infomercial of KLRCA and who we are. So KLRCA is an independent international arbitral institution where we were established by ALCO, which is the Asian African Legal Consultative Organization, back in 1978. We are the biggest and the oldest of the 5 ALCO centers. There's also one in Tehran, one in Cairo, and 2 in Africa, neither of which are functioning yet, but they will be quite soon. We're the domestic leader in terms of arbitration and in terms of ADR generally. We act as a repository of knowledge when you're looking at arbitration in various areas, and we take that quite seriously in terms of being a thought leader. You can see organizing conferences such as this today, the Sports Arbitration Conference, the 2 conferences running tomorrow as well. Internationally is something that we take quite seriously as well. We're looking at expanding. That's one point that I should really stress. When we're looking at the I-Arbitration rules and the way that they're drafted, initially the default authority was the SAC, but after some feedback, we realized that that could be perhaps not so welcoming and not of such utility to international parties. We definitely want the rules to be used by parties all over the world. In fact, some of the interest, the most interest has come from, of course, other than the Middle East, from parties in Japan, Korea, Germany, Brazil, Argentina. So we really want to try and make them as accessible as possible to parties from all over the world. And that's really the approach that we've taken with the rules and the 2013 revision in particular. All right, so we don't just do arbitration, mediation as well, adjudication, domain name dispute resolution. Particularly mediation is something that's quite important and something I'll touch on a little bit later in respect of Islamic banking and finance. In particular with the availability of the guidelines from SAC and perhaps with the increased predictability in relation to disputes in Islamic banking. As we saw in our mock earlier, often the parties can actually realize what the outcome is going to be at an early stage. So mediation is something that's quite important to assist the parties to actually come together and settle the dispute at an early stage. These are the products by which we actually administer the disputes. The one that we're here, of course, today to speak about are the ones on the far right. And just to give you an idea of the growth of arbitration, not only here in Malaysia but in the area, you see that since 2010, the number of cases that we've handled have really grown exponentially. I think that can be taken as an element of confidence in arbitration with the KLRCA moving forward. All right, so the reason we're really here. So selecting Sharia as the governing law. I think it's been hinted on during the day, the difficulties that exist when you are utilizing Sharia law as your governing law. It's not as simple as simply selecting the law of a nation. And I'll take you through why some of that is. So the specific needs of Sharia disputes. So generally we talk about the I-Arbitration rules in relation to Islamic banking and finance, but they are, of course, capable of being used in relation to any dispute in which Sharia issues will arise. Usually that will be Islamic banking and finance, but it's something that we should keep in mind. When you're looking at the Sharia law, you can characterize it in relation to 2 aspects. There's the procedural requirements and then the substantive. Procedurally, there are no established requirements as to how Sharia disputes should be dealt with. How do you actually treat a Sharia award? What is a Sharia award? There is some guidance from institutions, but generally there's no set way of doing it. There are some standards available, for example, the AOFI standards, but generally there's no set way of handling it the same way that you have, for example, the model law or the UNCITRAL rules. In relation to substantive requirements, the key issue here, of course, is establishing the governing law. What is the law that you're actually going to determine the merits of the dispute by? And it's important to contextualize these questions. You know, we're not talking about just here in Malaysia, but we're looking also at awards that are likely to be enforced in non-Islamic countries. So how are courts in Japan, in Korea, in Germany likely to look at awards that arise from Sharia-compliant arbitration? All right, so what is a Sharia award or a Sharia-compliant award? There's no uniform definition. There's nothing specific that makes an award a Sharia award. You know, generally when you're looking at Islamic finance, it's an award that resolves a dispute relating to Islamic finance, whether it be a single transaction or a matrix of dealings. So we saw earlier with the istisna transaction how you can have multiple contracts that relate to each other. It's clear that the Sharia principles will apply to the transaction and to the dispute generally, but in what way will the transaction actually be governed by those Sharia principles? The question that we've had to deal with is, should the Sharia actually apply to the procedure or just to the merits? And this, of course, will be crucial when we're looking at enforcement, as Professor Dato raised earlier. So the Convention broadly sets out, you know, the framework, the legal framework, the recognition and enforcement. The New York Convention, I think everybody should be familiar with by now, but it's you know, the key international tool that allows arbitral awards, foreign arbitral awards, to actually be enforced in other countries. And at present there are 155 signatories to the New York Convention. That was as of April, unless anyone's ratified today, which I haven't heard. And under the Malaysian Act, those same grounds are reflected in the Act under Section 39. So again, I must emphasize that those grounds must be considered from the point of view of a non-Islamic country, given that that is likely at some point that's where you want to actually enforce the award. All right, so the grounds under Article 5 of the New York Convention, and again reflected under most developed arbitration legislations, including the Malaysian Arbitration Act. You have the incapacity of the parties, invalidity of the arbitration agreement. You know, they're all mostly procedural issues. You'll find that there's no possible appeal on you know, points of law, errors in points of fact, and that's something important that we'll come to. Something important that I think we will discuss a little bit later with an issue that Dr. Professor raised earlier, with what are the repercussions of an arbitrator perhaps determining a dispute without considering the correct law. But one of the important ones, of course, at the bottom, breach of public policy. So the conventional Sharia award, what is a conventional? Is there a conventional Sharia award? You know, arbitration has been, of course, as I think has already been highlighted today, an important dispute resolution tool, you know, since the beginning of Islam, and even prior to that. So Sharia principles have traditionally been applied both to the substantive and the procedural. Right, it's difficult to specify really clearly what those principles or procedure will actually be. This is due to a number of different reasons. You have multiple sources, multiple interpretations, and multiple methods of application of the law itself. So this can result in procedures that are not necessarily compatible with the public policy of non-Islamic countries. All right, and that's going to give rise to problems of public policy and problems of enforcement. That's why this is something that's so important that we need to deal with. For example, and these more common in the past, but less so as Islamic countries do move to international best practice. You know, with the ways of dealing with the tribunal, who can actually be on the tribunal, qualifying the party's choice of law, rules of evidence, you know, practical formalities to do with the award. You know, there was a rather interesting case in Qatar recently where the award was not signed in the name of the Prince Emir, and that was deemed to be a breach of the provisions there, and therefore the award was set aside. You know, these kinds of provisions can give rise to issues when you're looking at enforcing awards in non-Islamic countries. So, moving forward, Sharia law as the governing law. You know, the main difficulty, of course, are possible ambiguities. All right. So often the desire is to combine with English or New York law. You know, and that's especially where there's complex financial dealings. And, you know, it makes sense. I mean, New York and English law are probably the two best suited to deal with banking and finance, not just in Islamic but conventional as well. And it's no surprise that parties do want to utilize those areas of law when it comes to resolving their disputes. Sharia law, of course, does not actually qualify as a national law the same way as English law or New York law. And different interpretations arising from different geographical considerations. And it's definitely a unique process when you look at incorporating it as a governing law. So the English court actually was asked to deal with this specific issue in the case of Mexico and pharmaceuticals. The governing law in that particular case was as such subject to the principles of glorious Sharia. This agreement shall be governed by and construed in accordance with the laws of England. The court refused to acknowledge Sharia law in this case as a concrete body of rules that it could actually rely on. It was a little bit more complicated than just that. There were certain, the Rome Regulations and Convention also came into play. But that essentially was one of the findings that they came to. So the problem becomes, how do you actually codify the principles that the parties wish to use in their dispute resolution? One way is, of course, to refer to a certain school or interpretation, which is what we try to do with the I-Arbitration rules, or by reference to an advisory board or expert. Looking at the different ways of applying the governing law, we must note that the position did change after Mexico Pharmaceuticals to a position now where Sharia is permitted as an applicable law in arbitration. Okay, and that's reflected in the model law and reflected in the law of most developed arbitration jurisdictions, including Malaysia. So while the parties cannot select Sharia law as a governing law in their litigation proceedings in most jurisdictions, they can still select it in their arbitration. So that automatically makes arbitration a particularly attractive dispute resolution forum for Islamic banking and finance, especially in cross-border disputes. Okay, so how can we actually do it? The most simple way, I suppose, is to refer to a governing law of a jurisdiction that incorporates Sharia itself. Okay, so an example of this is Saudi Arabia, and I've put there a couple of cases where that was actually what was done. So Al-Bassam, governing law in this case was law of Saudi Arabia. Glencore, they used the Fujairah Civil Code, and National Group Communications and Lucent, that again they use Saudi Arabia. There are many reasons why it is not ideal, perhaps when looking at a governing law, not least that Saudi Arabian law perhaps is not best suited for complex banking and financial instruments. Really, the idea behind commercial arbitration is not the party should have to settle for a lesser law. If the parties wish to utilize English law or New York law principles, they should be able to without compromising the Sharia integrity of their transaction. And that's really where we're coming from with this. So as far as we're concerned, although this is probably the easiest method of incorporating the governing law, it's not ideal. The next way is to actually define the parameters of Sharia through careful drafting. This is more difficult, but let's skip one. So the residual source of law first, which was in Sangi Polyesters. So the governing law used here was governed by the law of England, except to the extent it could conceivably conflict with Sharia. Okay, and this has not been looked upon favorably either, because as you can see by reading it, it's not really that clear. Right. In our opinion, I think the best way to incorporate the governing law still haven't figured out where the computer actually is actually through careful drafting of specific parameters. All right. So looking at the type of clause that Dr. Klotzel came up with earlier, although his was perhaps a little more complex. But Musawi International, the parties agreed to subject their agreement to Shia Sharia law with disputes to be referred to arbitration before an ayatollah. All right. So the effect of that is effectively that the interpretation of Shia Sharia law is specified not just to Shia, but then to Shia as interpreted by the ayatollah. Okay, and that gives a concrete body of rules that the tribunal can then rely on to actually determine the dispute. All right, so with that as the sort of theoretical academic background, we'll look at how that actually applies through the arbitration rules itself. So you've already been taken to the model arbitration clause. I won't take you through that again. There are, of course, the arbitration clause is a very important tool for counsel, for parties, when they're actually drafting their contract specifically with relation to Islamic banking and finance, because it is through the arbitration clause and through the governing law clause that they will essentially determine how their dispute is going to be resolved. And as we've seen, the implications of that are much stronger in Islamic finance than they would be in conventional disputes. All right, so I think we'll probably skip straight through to this. So as Professor Datta mentioned earlier, the rules are effectively the traditional KLRCA arbitration rules with some small modifications. That means that the rules will cover all of the usual procedural aspects: commencement of arbitration, appointment of arbitrators, challenge procedure, calculation of fees, collection of deposits, so on and so forth. Together with, of course, the more recent amendments, so interim relief, emergency arbitrator, that's all available under the arbitration rules, and of course the cost and time limitations that we try to implement in all our arbitrations. But the real crux of it is, of course, as we've dealt with, Rule 11. I'm not going to harp on it too much. I think it's been discussed at some length, but I will say just in answer to some of the queries that were raised earlier, so looking at the time limit of 60 days, I suspect if the SAC needed more time, the arbitrator will probably just give them more time. That's what I think would probably happen. And you'll note that under Rule 11.7, the arbitrator may go on and determine the dispute. It's not mandatory that they do so. And I suspect in a case where they're not actually able to go ahead and determine the dispute, then they won't. They will allow the extra time for the expert to come back and deal with it that way. I think when you're looking at issues of possible breach of natural justice, it's important not to get caught up in ideas of points of law. We have a difficult situation here in Malaysia, I suppose, where the Arbitration Act does allow for certain appeals on points of law to the High Court in domestic cases, and that has infiltrated, in many respects, the arbitration regime here in Malaysia. Whether or not you think that's a good thing is beside the point, but I think it is important that we remember that not using the correct law or perhaps incorrectly applying the law is on its own not a ground for setting aside an award. Breach of natural justice, and as has been discussed, it hasn't been tested, of course, so it's merely opinion. But breach of natural justice usually looks at whether a party has not actually been given the right to be heard. Those sort of procedural irregularities. So I think that if an arbitrator has been properly trained and deals with the dispute reasonably, whether or not they go ahead and actually determine the dispute with or without the Sharia Advisory Council or other experts' determination, hopefully will not call into question the enforceability of the award. But we'll be very interested to see what happens in the coming years. All right, so this is something that we touched on earlier. But when you're actually looking at the relevant counsel or expert, it is very important to actually take into account the characteristics of the transaction itself. Okay, because very easy. We are here in Malaysia. We've had several Malaysian practitioners coming up and speaking. We've had Professor very kindly come from the SAC to assist us in our mock. It's very easy to look at the SAC as the default body that should be actually deciding these areas. But as I said earlier, the international outlook is very important. We've actually translated the I-Arbitration rules into a number of different languages. It is our hope that the rules are used and utilized by parties across the world. They don't have to be seated in Malaysia. They don't even have to be administered by the KLRCA. To be honest, we don't care. If the rules are used by parties externally, for us, that is where the purpose of the project, and for us, then we've done a good job. So in that respect, when you're looking at what the applicable law will be, you need to really look at the characteristics of the transaction. If it is, of course, carried out by a bank licensed under the Central Banking Act, then yes, there will be mandatory laws that the tribunal will need to take into account. The SAC will likely be the body that will ultimately decide on any Sharia issues. But if that's not the case, well, then there are a variety of other bodies that can be used. This opens its own box of issues. If you're dealing with the Bank of Bahrain, for example, that bank is likely to have its own advisory board. Is that advisory board going to be the one that is competent to decide any issues, and will that give rise to any conflicts of interest? So these are the kind of next level issues that we're now starting to look at as we prepare the rules to really be used on an international level. All right, so I think this particular concept has been dealt with at some length already today, so I'm not going to go into it. But really, the only reason I put it here is it's an example of how the mandatory law here in Malaysia will actually function. Okay, so this is, as I said, it's not really something that arises under the arbitration rules themselves, which are the procedural rules. It's not something that arises under the Arbitration Act, which is the procedural law. It's something that comes in externally by way of a mandatory law. Okay, and in that way, we don't think that there's any conflict between our role as an arbitral institution and protecting the sanctity and enforceability of the arbitral procedure, and of course the public policy of Malaysia, and whether you think it's constitutional or otherwise, but requiring the SAC to be the authority and requiring their decisions to be binding. All right, another concept under the arbitration rules, which I think is a little controversial, the late payment charge. And this is a good example of looking at the different interpretations that do exist under Sharia law. If you ask parties from the Middle East, I think we had some gentlemen from Qatar here earlier, they would under no circumstances accept the late payment charge as applicable in their proceedings. Of course, it's an optional instrument that's available to the tribunal to utilize. And then, ironically, the late payment charge actually arose out of an arbitration case. So the tribunal in that case referred the question of how to deal with a default, a late payment, to the Sharia Advisory Council. They developed this mechanism, being the late payment charge, and this mechanism is now a guideline which you can find in their published guidelines. We've included it as an option for the tribunal to use, depending again on the interpretation of Sharia law that's applicable. And it's a good example of looking at how the different governing law will actually affect your dispute. If you're applying Malaysian law, if you're applying the SAC, then the late payment charge will be available to you, when you're claiming damages. If you're not, if you're using the advisory board of the Bank of Bahrain, then it's highly likely that it will not be available. It's also an example of the flexibility that we want to imbue in the I-Arbitration rules. So we've also included standard interest as an option. Okay, there's no reason that the I-Arbitration rules can't be used to decide normal commercial aspects as well. Okay, so if you have different aspects in the same transaction, you have Sharia aspects and you have conventional banking. The conventional banking may attract normal interest, and the Sharia may not. Okay, so this is in essence a complete toolbox for the arbitrator to be able to deal with every aspect of the dispute in the proper way. Okay, I won't take you into the specific the specific late payment charge mechanism itself. It's a little bit complex. It deals with the overnight rate of the Islamic money market, and there are certain restrictions as to how much can be recovered by the party and how much of it must go to charity. But it is a mechanism that in Malaysia at least works and is Sharia compliant. I mentioned earlier KLRCA's efforts in mediation. I think the earlier mock was really a prime example of the role that mediation can play in resolving disputes of a Sharia nature. Okay, a lot of the time the result is quite predictable. You don't have, it's not like in construction where you have competing experts who might take different approaches. If you have a specific interpretation of Sharia, that interpretation is likely to be quite obvious from the get-go. For that reason, we think that mediation, as much as the arbitration rules, will play a key part in the alternative dispute resolution of Sharia disputes. All right, so just in closing, I just want to close on this notion. Are we talking about Islamic arbitration of commercial disputes or the commercial arbitration of Islamic disputes? Okay, and this again comes back to the compromise that we were discussing. We've had visits from the Dubai Ministry of Justice, for example, and they've had some difficulty accepting that for a dispute involving Sharia issues, the procedure is not going to be entirely Sharia compliant, entirely Islamic. They sort of wonder, well, how can you apply commercial arbitration principles to an Islamic dispute? Of course, but I think we're sort of, looking at different target markets. KLRCA, we're looking at, as I said, there's been interest from parties in Japan, Korea, Germany, all across South America, across Europe. So really what you're talking about is a counterparty that is not used to Islamic procedures, and the other counterparty that is. So what you're really trying to do is find a middle ground where both parties are satisfied. Your non-Islamic parties are still receiving their commercial benefits that they expect from commercial arbitration, enforceability, efficiencies of speed and cost, control of the procedure, and at the same time, the Islamic party is not having to relinquish the Sharia integrity of the transaction itself. So that's really the sweet spot that we're trying to hit, and that's hopefully, I think, where we've come to. So that is the extent of my presentation. Thank you very much.